Ruckus. Thanks for joining. Please like, subscribe, and share. 10-8. Hey, what's going on, guys? Got my man Frank. Frank, how you doing? Let's check your mic, make sure I didn't screw nothing up. And I can't hear you. So let me see. Do you have it muted on your side, Frank? I can see where your microphone is muted. I think it's on your side. I'm going to say hi to folks while you try and find that. We got Miss Persevere and Miss Jinx throwing up those links. You're the bomb.com. I appreciate that. Rescue all the dogs. How are you? Olivia just became a member. Thank you so much, Olivia. I appreciate that. Let's see. Diddums. Hello, Diddums. Joan, how are you? Greetings. Raggedy Susan, how are you? Frank, I'm still showing the Purdue RN. Hello, Purdue. I'm still showing your mic is muted. There's a little thing on your side that you got to click to unmute that, brother. Hi, Gail. How are you? True Crime Fangirl. Shane Considine, how are you, my friend? All right, it's muted on my end. Let me see. No, it's not. Let me try something here, Frank. Guys, just give me 1 second. Let me try something.
There we go.
All right, I just had to. I had to bring up a fake camera. All right, so you with us now?
Yep, I'm here. What's going on, brother?
Hell if I know. Just saying hello to these guys. Had a lot going on today.
Yeah, a lot.
Hi, Willow Rain.
So I wonder how them pro-defense people are feeling right now. How butthurt they're feeling.
They're probably okay, to be honest with you. They'll figure something out.
I'm sure they always do.
Yeah. But it's good that we have people with that kind of mindset, to be honest with you. Mary Margaret, how are you? Alley Cat, what's going on? Yeah, the Attorney General was reprimanded and fined. I don't know what that was all about. I just seen something on that briefly today. I'm sure that's one of the things that that people will focus on.
Oh, I'm sure. Anything they can.
Charlotte, hello. Yeah, anything they can.
You know.
One more fail. I'm glad you found me. Oh, one more fall. One more fail. I'm thinking to myself. I'm glad you found me.
Man, there's a lot of people in here today.
Let's see. We've got 68 and 23 likes.
Yeah, come on, people. We need that like button hit.
Cleo was shaking. You can probably hear me without the microphone, Willow Rain. I have a big mouth.
Just 81 on my end.
Just had to get Frank rolling. Yeah, I'm showing 81 now, too.
Yeah, now people are starting to hit that like button. I can see it scrolling.
Right on. I appreciate it, guys. To like and share really helps the algorithm a lot. And I don't do that many shows, so I hate even calling them shows, to be honest with you, Frank. I like calling them live streams.
I mean, it's almost like they're since there's nothing going on, people are just coming up with anything to do a show about Delphi. If they know it's in the wrong, they're going to do it anyway.
I watched
You
a
know what
little
I
bit
mean?
of Sunday today, and a little bit of Defense Diaries, because she had an attorney on,
Yeah,
and
Travis.
yeah, and of course the Defense Diaries, they're both attorneys, so
Bob Mott and his wife.
they understand some of the terminologies that I wouldn't have had any shit. I can barely pronounce them. Never mind tell you what they fucking mean. I'm not too smart when it comes to that, but I make up for it with my good looks. So
But once you spit shine that dome.
yeah, I like to use a low sheen hard surface protectant.
All right.
That works the best. Solar Chef Steph, how are you, my dear?
Yeah,
All
I had
right.
to put a post up today. I was telling you about that. Somebody messaged me and said, thanks for clarifying that.
Well, that was nice of you.
Well, I mean, I seen some other creators already had thumbnails up and stuff were saying that the Supreme Court has made a ruling. And I'm like, oh, no. No, they didn't, guys.
I did too. What's up, She Warrior? I did too, dude. I'm a fucking nitwit.
But you corrected yours right off the bat because I'm sure somebody got with you about it.
Yeah, and then Deb messaged me right away, and then I read it because I put it on there, and then I started reading it, and I was like, oh, fuck.
Right.
And then Miss Persevere busted my balls saying, you can't make your mind up. This is like the third live thing that you posted today.
I saw another creator or two did the same thing, and I just posted it in the group that they're in that it's not what you guys are thinking it is. It's just briefs filed by the Attorney General and the judge.
Yeah, that's basically a response. Lakeside, I hope your surgery goes well, dear. Back surgeries suck.
I mean, this is what I do when it comes to documents, you know.
Yeah. Oh, yeah,
Make
no
sure
doubt,
they,
dude.
you know, so. But it is interesting to see that the Attorney General did respond. I mean, put a brief in after he had made it clear at the beginning of this whole thing that he would not represent Judge Gull in this whole case.
Mm.
And then all of a sudden, the day that everything has to be turned in, he wants to file a response.
Yeah. Hey,
So
Cecil Hotel.
What the hell's that about? You know?
I don't know if he's compelled to file a response or not.
Well,
He may be compelled.
Well, the state's top attorney, I mean, you would think he would have to, you know. Since he does represent the state. I mean, as far as the defense is concerned.
Right.
So, or the prosecutor's concerned, I should say.
All righty, what do you say we take a look at this?
Yeah, let's get on it.
Have you looked at it at all, Frank?
I just skimmed through it.
Okay.
Most important things were what his thoughts and opinions were. The very last one was the one that I was most important on. The last page was the one he was didn't agree with Richard Allen wanting the judge removed.
Right.
So he didn't agree with that at all. So that was more important to me than anything. So.
Hey, Boston Christian. All right, I'm going to look at some of this and read some of it. So if I miss some chat, I'll catch up. But you guys talk amongst yourselves. Talk about Frank. Don't talk about me. I'm very thin-skinned and sensitive.
Oh, I'm not in the mood for that shit today.
No.
Because I mean, another creator earlier today had posted a video over the groundswell, and I had made a comment. Boy, I had him on my ass after that.
All right, this is the table of contents. This is Judge Gull's response. Okay, she had till today to file it. I'm sure she had it done prior to this, and I'm sure that she'd been talking with the Attorney General, the state's attorney. So, the request that the court reinstate Baldwin and Rossi as Allen's court-appointed attorneys is inappropriate for a writ. So what I'm going to do is address these and then go to it. So that's on page 9. That way we're all on the same thing. Now, if you guys don't know, this table of authorities, these are all the cases that they cite. You'll see the little 1 or 2, footnotes. These are all the cases. It's like the appendix. Let's go to page 9.
Judge Gull came prepared. Believe that, guys.
Yeah.
Oh, yeah.
Okay, the response of relatives' petition to remove Judge Gull. Argument. An original action in a limited remedy is a limited remedy governed by strict procedural rules. Jesus Christ. I'm out here on the sun porch, and it's actually cold out here. Procedural rules. Original actions are viewed with disfavor and may not be used as substitutes for appeals. Original action rule, and they're citing one of the cases. Before a writ will be entertained, the realtor must raise the question by written motion to the trial court. And if a remedy by way of appeal is full and adequate, a party may not invoke the jurisdiction of the court under the original action rules. A writ of mandamus will not issue unless the realtor has a clear and unquestioned right to relief and the respondents have failed to perform a clear, absolute, and imperative duty imposed by law. So what they're saying here is in this lower court, they have to excuse all of their options first to remedy this. They can't just jump right to the top. That's a no-no. You can't just go straight to the Supreme Court of the state. Everybody's overlooked that this far. If that was the case, then everybody would do that. We'd never get any trials done. All right, well, I'm seeing some, page 9 gets back in here again. So I'm just going to go down through it, like right here. One of the appendix.
This is the Attorney General's response.
It is? I thought this was Gull's.
No, it says right here.
Okay. I wanted to start with Gull's, but that's okay. We'll go backwards. I've got them both lined up.
It says right there, right at the top of that, Indiana Attorney General.
Mm-hmm. Mm-hmm. Todd, what is it, Rokita? Rokita. Okay.
Theodore Rokita.
All right, so what he was basically saying there, they wanted to get her removed and they wanted to have some remedies and stuff. And he's basically saying, listen, you didn't even ask for any of that stuff at this court level. So right off the bat, he's saying that, listen, you're not even following correct procedure. You're asking for something extraordinary and you're not following correct procedure. Hey, Miss Thing.
So they basically jumped the appellate court before and went right to the Supreme Court and they didn't follow procedure themselves.
Well, they didn't even have grounds to appeal yet. It's easy to say that she violated their rights, but they didn't prove it. They still haven't.
Right. I think the transcript itself alone basically clearly shows that they were going to remove themselves no matter what, because they knew exactly what was going to take place before the 19th even arrived. That's just from the phone conversations and the emails between the parties.
Yeah.
The judge and the attorneys. Self-explanatory. She basically told them what was going to happen on the 19th.
Yeah, absolutely. What's up? This will do nicely. All right, so background. In 2017, 2 teen girls were murdered near Monon High Bridge Trail in Delphi, Indiana. Richard Allen was charged with the murders on October 28, 2022. On November 14, 2022, Special Judge Francis Gull appointed Bradley Rossi and Andrew Baldwin to represent Allen. In October 2023, discovery subject to a protective order was leaked to the public. And what they're talking about there is the crime scene photos. And some of the discovery. Discovery was released prior to that, but I'm sure they'll address that. On October 12, 2023, Attorney Rozzi wrote to the court acknowledging that the defense team was the source of the leak and arguing that disqualifications of attorneys Rozzi and Baldwin was not appropriate remedy. Judge Gull set a hearing for October 19, 2023 to discuss the upcoming hearing on October 31st, 2023 and other matters which have arisen. We all know what those matters were. Baldwin retained an attorney for the hearing. And as soon as I caught wind of that, right, I don't know if you guys know who Mark Lopez is. Do you know who it is?
Yes.
Yeah,
he defense attorney has his channel.
Yeah, and he's awesome. He's awesome. So I texted him and I was like, "Hey, bud, did you hear that Baldwin got an attorney?" He goes, "Where'd you hear that at? Because I have not heard that." So I didn't want to disclose where I had heard that from. So what I did was I reached out to Baldwin's office and sent them. They have on their page, a live chat thing, and it started there. She asked me for my name and phone number, and then they called me the next day, and they basically told me to go outside and play hide and go fuck myself. They wouldn't tell me. Yeah, I didn't expect them to, but
well, that means they knew who you were.
Yeah, exactly. Well, they asked me if I was a YouTuber, and that I have a podcast, and I said, yeah, I do. I wasn't going to lie to him.
Right.
Get him, Blade. Get him, Blade.
There he goes.
At a chambers meeting before the hearing, Judge Gull informed Baldwin and Rozzi of her concerns regarding the defense team, the totality of the circumstances surrounding the representation of Mr. Allen. Judge Gull outlined her concerns. Now, just to touch base on that, people that were saying, and they, to be honest, to give them their credit, they were saying it because the defense attorneys were saying it. But people were assuming that they were ambushed and they didn't know what was going on, and Judge Gull was playing dirty, and Slick Nick knew everything and had some witnesses there and this, that, and the other thing. When these guys absolutely know what was going on, otherwise Baldwin would not have hired an attorney. And that's why I wanted to speak with him, but of course that was chances of that were slim to none. But he hired an attorney. A few days later, Richard Allen writes a letter to the court saying, "Hey, I don't want these guys removed." And then 4 or 5 days later, they have this hearing, and I'm not talking when it was filed. He signed that and submitted that a couple days before it was filed. And now they're playing like they were ambushed. When Attorney Rozzi, however you want to say it, it doesn't matter anymore because he's not with us anymore. He's gone. Bye-bye. But he's the one that called that little huddle. That's right in the transcript.
Yeah.
A lot of the pro-defense people were saying, wait till that transcript comes out. Yeah, she doesn't want that to get out because she knows she's wrong. Well, no, not so much, huh?
Boy, I could just say so much right now, but I'll bite my tongue.
Yeah. Well, it's turned into a nice little discussion. You know what I mean? It is. There's definitely a line drawn in the sand, and that's fine. I don't mind that as long as there's name calling and doxing and all that. I don't mind at all. I like going back and forth. All right.
Like I told you, I commented today on some of the people that did a video on the groundswell today. I said, y'all are a joke, man. I said, it looks like your little rally didn't turn out as planned, did it?
Well, I was surprised. I don't care that they did it. I don't care why they did it. That's their right. I was surprised. I called it a sinkhole instead of a groundswell because of the numbers. Nobody showed up.
Right.
Yeah, nobody showed up.
And some of the main people that were pushing it weren't even there.
Yeah, when you're calling cadence like we did when we were marching, and there's only like 4 people responding back to you, it just doesn't sound as intimidating as if you had, 50 people responding back. All right, Indiana Attorney General responds to Realtor's petition. Okay. Improper comments to the public. After stating they would not talk about the case, Baldwin and Rozzi issued a press release that was potentially violative of the ethics rules. Okay, so they were skating. We all knew that. I remember saying, "Man, I like these guys. They don't give a damn about the rules. They're going to do whatever they can to get them off." What's up, James? Then conflict of interest. Rozzi filed a tort claim on Allen's behalf against the DOC. I don't really see a problem with that, to be honest with you, Frank. You know, if why can't he file it and then turn it over to somebody else? You know what I mean?
Yeah, it's typically how it's gonna work anyway. I mean,
Yeah. All right, people are
I
saying
mean,
they can hear me fine, but you sound like you're a little far away from the mic or something. I've got you
let me
turned
see.
up as high as I can on my end, brother.
Let me see here. I'm all the way up too. Can y'all hear me just fine? Y'all hear me just fine?
I have a big mouth, though. Okay, and next, we have a protective order violation. Baldwin negligently released discovery to Brandon Woodhouse, who disseminated it to the public. Baldwin did not alert the court or the state to the release. Now, let's address this, shall we? So he's typing in his address on the address bar for his email. He gets to BRA because Brandon is BRAN and Bradley is BRAD. So he just got the BRA and picked the first one. I don't know how small his contacts list is. And he's hit send. Now, the next day or the day following that, he doesn't ask Rozzi, dude, did you get my email? I sent you that shit and I haven't heard back from you. No, nothing like that. Right?
Right.
Nothing
Right.
like that. And it just so happens to go to a felon who's also just had a tort claim against the county, and also it just so happens he's a practicing Odinist. Right? And we now know because of the deleted Reddit post. Now, I know that people can get those, even though they've been deleted. They have like the Wayback Machine, whatever they call it. They can pull those. I just don't trust them to be manipulated. I believe that they can pull them, but at face value, we're talking way back that people were talking about the Odinist stuff in Reddit. These people that were defense friendly, talking about how they're going to plan to use the Odin angle. And that's in those Reddit discussions. So they were privy to that information months and months and months before that Frank's motion.
Yeah. Well, that's because Mr. Fortson was in Reddit.
Mm-hmm. Mm-hmm. So is Mark.
Yeah.
So other people. There's a guy, I'm not going to say his name. People know him by his name, but I'll call him what he wants to be called, and that's Norak.
Right.
He's a smart dude. He's no dummy either. All right, so next, anyways, with that whole thing, and I am here to tell you, everybody that's listening, we got 106. Brandon Woodhouse had some of the actual discovery, and he had photos to include the crime scene photos. So everybody is saying, well, he just got pictures of the index. Get off it, because he got photos and some of the discovery files.
Yep.
That index, some of the index things were blue. So you click on them, it could be 5 pages, could be 1,000 pages. But he definitely had photos as well, and he knew about the Odin stuff. He knew about the F tree. He knew about all that stuff, and there's no doubt about it. It's a fact.
Well, that stuff was out a long time ago, though.
Well, it's hard to say which leak. It's almost been like a continuous leak. That's why I really don't care about it. I don't care about all this shit, to be honest with you. All right, filing motion. Go ahead.
The original leak started a year and a half ago.
I believe they started before that with Erskine.
Well, that was just with the text messages, and then the photos came after that.
Yeah, Miss Thing, I deleted my Discord. I didn't hardly ever go in there. Hardly ever. And some people just couldn't handle the fact that it was the People's Discord. It was the Wild Wild West. So, all right, filing motions with inaccuracies and falsehoods. The pleadings regarding safekeeping Allen and the DOC contained proven false information. We had affidavits from the guards. But even then, people still said, oh, well, they admitted that they wore Odin patches. No, that's just not true. Protective order violation. Baldwin was a source of more leak discovery, which spawned a criminal investigation and may have resulted in a suicide. We don't know what resulted in that suicide. You know, that guy, Fulton, was telling people that he was an attorney and that he was on the short list to represent Allen, actually. And he was working closely with the defense team, and none of that was true. It was just online bravado, you know. Hi, Kristen. How are you?
What's going on, Kristen?
It was just online bravado, and to be honest with you, Norak and Lordless Warrior, who was Fortson, they just got in a pissing match on who knew what and who didn't know what, who was full of shit, who wasn't full of shit.
Right.
That's how all that shit came down. And I can see it happening. You know, I'm not very well versed on the ins and outs of this internet social stuff, but
I
Judge
try
Gull,
to stay out of it as much as I can when it comes to all the drama that goes on.
well, you can learn something through every conversation. There's no doubt about that, whether it's drama or
Right.
not. But yeah, sometimes it just goes too far for no apparent reason. You know.
They're just trying to show their balls and shit.
Alley Cat, they said they wore patches. Their affidavits are out.
Yeah.
They said they wore patches, but they weren't Odinists. I think one of them said that maybe one of them could be misconstrued as Odinist, but they weren't Odinists. They didn't know anything about Odinism. All right, Judge Gull found that Baldwin and Rossi had demonstrated gross negligence and incompetence in representing Allen. Judge Gull stated she did not want to say this in open court, but would if she had to. Judge Gull confirmed that Baldwin and Rossi did not withdraw. She would remove them, that if they didn't withdraw. After consultation with Allen, Baldwin and Rossi chose to withdraw. Now we know that is the truth now. I would like to hear it if they recorded that so you can hear the tone of voice and stuff like that. But you don't have to be a rocket scientist. A lot of the time she's saying mm-hmm or mm-mm. So she's being a little snarky. There's no doubt in my mind. No doubt in my mind at all. When withdrawing their appearances, Baldwin and Rossi claimed it was unfair because they were forced between being accused of misconduct in open court or withdrawing. In open court, without Baldwin and Rossi present, Judge Gull announced that they had withdrawn. Now, I wish she just went ahead with that hearing.
Right, exactly.
She won't do that shit again. That's for sure. All right, and here's a response to another part of the petition. Rossi tendered 2 documents on October 25th, 2023. A notice that he was still Allen's attorney and a motion to disqualify Judge Gull. Judge Gull took no action on these filings because Rossi was no longer counsel of record. On October 27, 2023, Baldwin's attorney, David Hennessy, filed a motion to reconsider, claiming that there had been no valid motions to withdraw by appointed counsel. On October 27, 2023, Judge Gull appointed 2 new attorneys to represent Allen. Now, I don't think it was too wise of her to appoint 2 attorneys from her county. I think that was stupid, to be honest. Of course, people are going to say that, and one of them had already made a statement being interviewed that the ballistics evidence was not junk science and that it was good evidence. So he's already got an opinion on that. So whether you like Baldwin and Rossi or not, they threw caution to the wind trying to protect their client. We haven't seen how these guys are going to do, but I think it would have been wiser for her to pick people from either Carroll
Another
County or somewhere else, not her county.
right.
It's just fueling this corruption talk. What do you think about that?
I totally agree. I totally agree. She knows these guys personally. She works with them in the courts. I'm sure not on a daily basis, but you know what I mean.
From what I understand, she's friends with at least one of them on Facebook too, which doesn't help.
Right.
Yeah.
Which I totally agree that argument there. You know, maybe the Supreme Court might do something about that. You never know. You know?
Now I was curious because when she said, "No, they're not counsel anymore," so anything that they file after the 19th, take it off, strike it. I don't want to see it. I want to hear it. It doesn't count. They're not here. They're ghosts. So I thought that was interesting.
Yep.
But I guess they're going to bring those back and make those public, which we've already seen them anyway. But
right. And like I said on the 31st hearing, you should have seen the look on her face when she walked in the courtroom and saw Baldwin and Rosie sitting at the defense counsel table.
Dude, that was beautiful.
And then the new attorneys are sitting in the witness seats behind them, and I'm thinking, oh, this ain't gonna look good.
Yeah. It was like on Seinfeld when George Costanza got fired by the Yankees. He quit. And then he realized he made a mistake. And Kramer said, "No, just go back in Monday like nothing happened." So that's what he did.
And now I got Cleo saying I sound like I'm in the bathtub.
You sound fine to me. So, yeah. Well, Kristen says they have a pool to choose from, which is true. They do. I don't know if the fact that they need to be death penalty certified, the death penalty isn't even on the table yet. They just have to be certified because this is a death penalty case, should the prosecution decide to go that route. I think he's going to keep that in his pocket and try and get him to plead out. Frank, can you imagine? I think he's going to plead out, personally.
I do. I do too. I mean,
but can you imagine if he does? People are going to lose their minds.
Well, then all we can say is we told you so.
Well, it's not even that. I mean, they're going to say he was coerced, he was threatened.
No.
Hello, Miranda.
Come on. I mean, it's just like this crap. I mean, they done tried to pull this stunt one time already with the discovery when they gave it to Richard Allen. And then they pulled that little stunt that, he's mentally ill now. Well, that's because he saw what they had against him and he's flipping out.
Yeah, absolutely. Absolutely.
I mean, who in the hell wouldn't, All
right, let me turn my mic down.
Why, is somebody saying something?
They're saying that you're soft and I'm thundering. But I do have a big mouth. You guys let me know if that level's better. At a hearing on October 31st, 2023, Baldwin and Rozzi were present. Having tendered appearances the day before, Hennessy also appeared for Baldwin. Now, that cracks me up, too. Baldwin hired an attorney. Rozzi didn't. That cracks me up, too. What's up, Ashley? I just sold a car. What's up, Frosty? Baldwin and Rozzi did not attempt to present evidence or rebuke Judge Gull's factual findings, finding that nothing had been altered in the court's concerns about counsel's gross negligence. Judge Gull disqualified Baldwin and Rozzi from representing Allen. Hennessy withdrew his appearance that day. Hennessy said, "Fuck this. I'm out. I'm off like a prom dress. I ain't getting involved with this. What kind of shit you get me into, Andrew?"
Like I said, man, you should have seen the look on Gull's face when she walked in. You could see the blood pressure rising in her face. She saw them. The first thing she did, she sat down in that chair and leaned forward all the way to the front of the judge's, whatever you want to call it. Leaned all the way forward
bench.
To make sure. Yeah. I was like, she's about to have a coronary right here.
What's up, Mayo?
Yeah.
All right, no attempt was made to appeal Judge Gull's order. On November 6, 2023, attorneys Kara Wenke and Mark Lehman filed a petition of writ of mandamus with the court, asking the court to order the trial court to reinstate the attorneys, Baldwin and Rosie, and to order the trial be held within 30 days of granting, 70 days of granting the writ.
There's the problem right there.
That's a situation?
That's a situation because of the fact is the 70 days had lapsed from his original arraignment to get him in trial.
Right. Yeah,
And then,
I mean, they're trying to say
that
that he's demanding a speedy trial now. I don't know if that's possible at this point.
I don't think it is because me and you went over the Indiana law. They've got within, 100 days from the time he's arraigned, which was October 28th of 2022, to get him in the speedy trial. It is not the court's fault that he did not have representation because he told the court that he was going to hire an attorney.
Right. A lot of people do that.
And it does not stop the clock on a speedy trial.
I got a $5 super chat from Mayo. I just wanted to give him a shout out. I appreciate it, Mayo.
Yes, it does not affect the time clock.
Hey, you've gone from the bathtub to the attic. Is my mic sound okay, guys? Am I still too loud?
How's that?
You sound fine to me, my friend. I don't have any problem. All right, let me get back on the reading here. Now, they want to remove Judge Gull. They want those attorneys to be reinstated. And they want to have a trial within 70 days. So they're asking for a lot. And so what the Attorney General is saying is like, look, you can't do that. That's not how this shit works. You know?
They bypass the appellate court.
Yeah. Now I sound like a duck. All right. Well, you got Frank in the tub and I'm a duck. Maybe he's taking a bath and I'm his rubber ducky.
Well, Shane said we both sound crystal clear to him on his end.
Well,
how many old folks do we got in the chat to where they're having hearing problems?
Yeah, dude. If they're watching me, they got to be old. All right. So this is the response to remove the judge. The argument: an original action is a limited remedy governed by strict procedural rules. Original actions are viewed with disfavor and may not be used as substitutes for appeals. And that's what it appears that they're trying to do. You know, before a writ will be entertained, and this is what I was saying earlier, you just can't go over the court's head. You have to go through the lower court. You have to address it there first. I'm guessing Ruckus is closer to the mic than Frank. I don't know. If I turn mine down, you won't be able to hear me. But what's going on, Antonio?
What's going on outside the grid? There's Miss Marie, V. Marie. Where you been hiding, girl?
Hey, V.
Lord, she's been gone for a while.
An original action is a limited remedy governed by strict procedural rules, blah, blah, blah. We just did that. So before they'll entertain a writ, you have to try and remedy this stuff at the lower court level. The relator must raise the question by written motion to the trial court. Now, we know that in the transcriptions of that meeting they had in the chambers, she said at least twice, do you want a hearing on that? I'll gladly give you a hearing on that.
She was wanting to do it that day.
Yeah, but she's saying, you know, if you believe that you've been wronged, let's have a hearing on it. That's the procedure. That's the way this shit works. You're trying to just jump right up over my head and, you know, we should have a hearing on it first. There's no precedence here. You can't say I did something wrong to you because we haven't addressed it. You can't say that I ignored your wishes because you didn't file anything. You know, if remedy by way of appeal is full and adequate, a party may not invoke the jurisdiction of the court under the original action rules. So a writ of mandamus will not issue unless the realtor has a clear and unquestioned right to relief, and the respondents have failed to perform a clear, absolute, and imperative duty imposed by law. So that's all she's saying is that, look, you're trying to get this writ of Miranda's done. No, this is what she was saying. that,
Right.
you didn't file. I'm talking about the transcript. She was
Right.
telling him, listen, you didn't file. So this guy read that, the attorney general read that, all those transcripts and stuff like that. And he's saying, okay, well, show me where they filed. They didn't. Well, then she's right.
Right.
You know, the request of the court reinstate Baldwin and Rossi as Allen's court appointed attorneys is inappropriate for a writ. He's not saying it's inappropriate. It's inappropriate for a writ. Hey, Red Queen. A writ of mandamus reinstating Allen's former attorneys is not presently warranted. The conditions precedent for a writ are not satisfied, as a claim was not clearly presented to the trial court and remedy by appeal is adequate. Even where the court to review the merits of the Allen's request, the record is not sufficiently developed for the court to resolve the question. They didn't file it correctly by going straight over, do not pass go, do not collect 200. They just went right past everybody. They went around, they circumnavigated how the court system works. And I could be wrong here. Anybody here that works with the courts or as an attorney, or I'm quite sure that at least 99% of you in chat know more than I do. Please correct me on that.
I'm sitting there reading, dude. So
No, you're fine. Appeal is both adequate and preferred to review whether a trial court abused its discretion in removing counsel. Allen did not seek interlocutory
yep.
appeal of either the trial's court order granting withdrawal of counsel or its subsequent order declining to allow counsel to appear pro bono. Now, do you know what interlocutory means?
Mm-mm.
I'm going to have to find out.
Hold on here. I'm going to look it up now. Let's see.
I'm going to keep reading a little bit while you do that. The record does not indicate that Allen asked his newly appointed counsel to appeal, nor does Realtor explain why original action counsel could not file a limited appearance to seek certification of the court's order, as counsel did to file the motions in preparation of this action. The
All
writ
right,
of
here we go.
Go ahead. Does it mean in the middle?
Huh?
Does it mean like down the middle?
No, it says of a degree or judgment given provisionally during the course of a legal action and injunction. There was no injunction ever filed.
Okay.
Basically what they're saying.
Okay, so they didn't seek an injunction. Okay. Why couldn't they just put that?
The term is used to indicate a lack of finality.
Okay. The writ of mandamus cannot be used as a substitute for appeal, right? This is the second or third time that he said that.
Yep.
They are supposed to be really, really good attorneys with over 50 years of experience, but didn't know these rules. I call BS. Yeah. I think, honestly, Kristen, that this case, Kristen, if you and I were attorneys and we got assigned this case, I've seen some of this shit. I've seen some of the discovery. He's screwed. You got to do whatever you can. They're trying to be a little bit more sensational than they needed to be, and I think that's because who's upset, Brad? And I think that's because they got booted, but they're just trying to get movie and book deals.
There are some of us creators who are in the same boat. There's things that we know that we can't say anything about, but we know it points right at Richard Allen.
Absolutely. I'm here to tell you Richard Allen did it. Disqualification of counsel. Now, that doesn't mean I don't believe in due process.
Right.
At all. Disqualification of counsel can be required or it can be at the discretion of the trial court. Now, see, can be at the discretion of the trial court. So she does have the right to disqualify him. She can disqualify him. Now, there's guidelines that she has to follow. They have to do this, or this. But she laid it right out on the line what they did.
Can you put this comment up by Rescue All Dogs, that word? She's got the definition.
I should have known she would. A decree
Yeah,
or
there we go.
judgment given provisionally during the course of a legal action, an interlocutory injunction. All right, so it's just something they say, all right, for right now, we're going to do this until we
Right.
figure out what's going on. Okay. Hey, Lee and Susan. Yeah, they're used to getting their own ways, right? Yeah.
Yeah, see, and that's exactly what I was explaining to somebody earlier. I said basically what they were trying to do, they were trying to use their stature and their their years of experience, and they were trying to bully Judge Gull. That's how I felt about it.
Hmm. And now an action for mandate cannot be employed to adjudicate and establish a right or to define and impose a duty. Now, they keep citing these cases, so they did their research on it. So there is precedence for all this stuff. As I can imagine. This is like all of us creators that are arguing back and forth. That's what's going on here. These attorneys are arguing back and forth, and it's leading nowhere. It's
They're
to me,
wasting paper, honestly.
and time and money. I don't care. Bring the other attorneys back in. Get a new judge. Get a new prosecutor. Get new attorneys all around. I don't care. Let's just get them to trial. The facts of the case don't change, and the evidence, it doesn't matter who presents it. It should stand. Yes, I do, Cleo.
Yeah.
TLS, how are you? I do believe I know other people are involved, and there's going to be other arrests.
Yeah, I do believe it too.
Just remember, history will remember what side people were on. All I will say. I remember people that took Ted Bundy being innocent to the wall right up until he confessed. And then they said that that was a forced confession. Gladys Kravitz got a super chat for $9.99. Thank you so much, Gladys. That helps a lot. I should have a trip coming up here pretty soon. Every little bit helps. I'm here because I trust these guys to be objective. Yeah, and I am biased, Brad. I've said it a million times, but there's a big difference. It's a big difference. I'm biased because I feel law enforcement has done their job. All of this is smoke and mirrors, sleight of hand, trickery,
and see, I feel the same.
theatrics.
I've had people make comments to me, you're just biased, da, 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 you're a spokesperson for the family, da, 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 da. It's not about the family, it's about Abby and Libby. Period. This is what this is all about. I don't give a damn about all the theatrics that's going on behind the scenes with other creators. I don't give a shit about all that. You know, you all go out there and make asses of yourself. That's why I stand low key, keep to myself. I know what I know, and I sit on it until it's time to release what I know.
Brad, thank you very much. $19.99 super chat.
Thanks, Brad.
If he pleads out, which I believe he will, right, I'll start answering questions, right? And I'll start giving up sources. Or once the trial starts, and it's not a matter of, hey, I want to be first. That, hey, look what I know. Well, no, here, this will help you make sense of what's going to happen here, you know, because I can't change the course of this case.
But honestly, like we talked about just a little while ago, that attorney admitted to the ballistics being good evidence. I think he's going to end up going to Richard Allen and say, hey, look, they got this, and this on you, and there's no way around it.
But just because he thinks that that's solid science doesn't mean that he can't fight it.
Right.
Yeah. Gail, he was definitely trying to, they were trying to try this case in the public is what they were doing. They were trying to see what sticks. We are all in the jury pool, so they could get a good idea, a yardstick of what everybody's feelings were, what was going to work, how they could present the case, because they don't care about the prosecution. They care about one member of the jury. So they're trying to do anything to get a good yardstick on what everybody's thoughts were. More people that know more should learn to keep their mouth shut. Not everything needs to be public knowledge. My lips are sealed, laughing out loud. Oh, I hear you,
Yep.
TLS. But when you
Yep.
see, I don't know, you're right. I mean, there's no excuse. You're right. I never tried to be malicious. I wasn't trying to get attention or anything. That's why I don't do many lives. I pretty much moved on from this case, but this stuff here is interesting.
Yeah,
The legal
I
battle.
mean, Miss Purdue RN, she's always given me this advice: loose lips sink ships.
Well, you know my advice. I do what I want.
Right.
Yeah.
What's
What's
going
up,
on,
Kev?
Judge Kev?
All right, let me get back to this. Court has reviewed disqualification of counsel to original actions. Blah, blah, blah. We did that. Statutory authority. And I'm just reading ahead a little bit, guys, because nobody really cares about these cases that they're citing. If you want to look them up, you'll be able to see. But then you've got to read the whole thing and try and decipher what they were looking at and pulling out of it. But appellate courts have reviewed discretionary removal of counsel to interlocutory appeal again. So they're using the same process. Removal here was at the discretion of the trial court, so mandamus is inappropriate. So remember, she called it moot. It wasn't inappropriate to her. She said it was moot. Allen does not identify as absolute duty to reject counsel's withdrawal or to permit them to reinstate representation. So the law does not place an absolute duty upon the courts not to interfere with the attorney-client relationship, but it bars arbitrary and unjustified interference. Allen contends that respondent acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. But Allen does not identify the origin of this absolute duty. Allen's brief does not contain the verbatim statement of relevant parts of all cases, statutes, and other authorities relied upon, required by the rules. Such a statement is necessary to define the source and scope of the duty that Allen seeks to mandate. The trial court's authority to remove counsel is more nuanced and less absolute than Allen suggests. Now, we all know Allen did not write that letter to the courts. He didn't write that. They wrote it, and he signed it. Right, Kristen, he is indigent, okay, so he gets assigned an attorney. Now, he can have a say in... I've seen him where, even twice, where they've assigned them new attorneys because they just can't get along with their client. And mostly 9 times out of 10 is because the client's an asshole, but sometimes it's because they're both assholes. But he can have a say in, no, I don't want them removed. It's my moon, Loretta, how are you? But if there's gross negligence like this and incompetence, he has no say. And we're finding that out right now, aren't we, Kristen? He's finding out the hard way. Give me 1 second. All right, sorry about that. The Sixth Amendment guarantees every defendant the assistance of counsel. Those who do not need counsel appointed also have the constitutional right to choose counsel. But indigent defendants do not have the right to choose appointed counsel. So that means he couldn't say, yeah, I'm indigent, I need a public defender, and I want these people. He can't do that.
Right.
But once you've established a relationship, you do have somewhat of a say. The United States Supreme Court has not recognized for appointment or retained counsel a distinct right to continuity of representation, and the court has rejected a constitutional right to a meaningful relationship with counsel. But the Sixth Amendment's purpose of ensuring a fair trial imposes a baseline requirement of competence on whatever lawyer is chosen or appointed. That should go without saying. That should not have to be written down.
Can you imagine the look on Kathy's face when she saw the interview with that attorney saying that the ballistics was good evidence?
Yeah,
Can you imagine the look on her face?
it is good evidence, though.
Yeah.
I mean, I'm gonna have to put I'm gonna have to
All
put
right.
that case up, that
We
precedent suit.
got 139 in chat and 81 likes, guys.
We got one dislike too, so you got to count that one. That even
I don't
helps,
see.
believe it or not.
I don't see that. Not on my end. I don't.
Yeah, I get them all here. I can see it all in this program. The right to choose counsel is not absolute, while the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that the defendant will not inexorably be represented by the lawyer whom he prefers. But for retained counsel, courts must recognize a presumption in favor of the defendant's counsel of choice. So they do their best to let him have who he wants. If they assign somebody that they just can't get along with, then they'll give him somebody else. I've seen it where a client will get two, sometimes three sets of attorneys or individual
Mm-hmm.
attorneys. Indiana does not address whether the distinction between retained and appointed counsel alters a court's authority to substitute counsel. And authority is mixed in other jurisdictions. Now, let me ask you this, Frank. Say you hire an attorney, and that attorney pulls the same things that these two did. Do you think Judge Gull would have had the same authority to remove them?
No. No. I think she would have had to pay, some type of paperwork would have been filed for that.
What do you guys in chat think? If he hired these two guys, if they weren't appointed, if these were his personal attorneys, you think Judge Gull would have took the same course of action? All right. The Colorado Supreme Court recently held that indigent defendants have no constitutional right to continued representation by appointed counsel. Now, the only reason why, and I'm sure people are going to say, well, this is in Colorado, this is Indiana, because we're talking about constitutional rights. The court found that any right to continuity of counsel must flow from the right to choose counsel, which indigent defendants lack. But the court recognized the indigent defendants have an interest in continued representation by appointed counsel if they can demonstrate that prejudice would result from substitution with a different court-appointed attorney. Trial courts must give great weight to a defendant's preference. Whether requiring a presumption or a weighty consideration, trial courts must weigh a defendant's preference for representation against circumstances favoring disqualification. So once they're assigned, to the defendant, well, then it becomes a whole different story. Now they're representing him, so they have to give more weight to it.
Right, and that's why I said that she has no legal authority when it comes to hired attorneys because it's on a different scale there.
Mm-hmm.
They don't fall under these rules, under the constitutional rules, when it comes to appointed attorneys.
Yeah, but see, this is kind of a double-edged sword because an attorney's an attorney. They all go to the same law school. So whether they work for the public defender's office or they have a private practice, these two attorneys have private practices, but they're in essence public defenders because they're hired by the state to represent this guy.
Well, like Kristen said earlier, that there's a list. Every attorney has to donate some of their time to be doing pro bono, which would be public defender work or whatever. Mm-hmm. So technically, they're working under the state pay and not their own hourly pay that they would normally charge for their law firm.
I'm sure they get some kind of per diem, though. They work around that stuff
because they had $1.1 million. They better have enough money to play around with.
Yeah, but yet Nick has to beg for $5,000.
Right, exactly. And which I don't think that's on the county. I think the state should be paying for all that. But then again, I know how it works. The state allots each county so much funds for their prosecutors, and you know what I'm saying?
Cleo, there you go. His alias was Craig Ross Renfro. I don't know where
Yes.
that came from, if that came right from Richard Allen or they found it through other avenues.
Other avenues. We did some background on him, and he was using an alias.
Okay, so this statement here, right, contrary to Allen's claims, more than two circumstances may require a court to interfere with a defendant's preference for counsel. As Allen recognizes, a defendant cannot insist upon counsel who is not admitted to practice. So once she told them you're out, they're out. They're out until they've got to file with her. And I'm sure that if they filed correctly and all that, all of this would have went a different way. She wanted them removed, but it wouldn't be this messy. And the court may act to remove counsel when the representation creates an actual or serious potential for a conflict of interest, including refusing to permit the defendant to waive the conflict. So if she even thinks that there's potential for that to happen, she's absolutely fine with removing them. But these are not the only circumstances that allow interference with preferred counsel. Counsel's conduct or personal circumstances may justify removal. Gross incompetence or physical incapacity of counsel, or what is that? Contumacious? What is that one? Rescue all dogs. Contumacious.
Continuacious.
I don't know. I'm gonna need somebody to look that up.
Where's Rescue All Dogs at?
Yeah, that's a new one on me. That cannot be cured by a citation for contempt may justify the court's removal of an attorney, even over the defendant's objection. I'm waiting to see if that pops up. A trial court may disqualify an attorney for violation of rules of professional conduct that arises from the attorney's representation before the court. And a defendant may insist on the counsel of attorney who has been previously or ongoing relationship with an opposing party, even when the opposing party is the government. Boy, that must be a hard word to find out. I figured somebody would know by now. The need for effective administration of justice may require removal. So,
hold on, I'm reading something here. What the hell is the Red Queen saying?
Especially a defendant's behavior, stubbornly or willfully disobedient. Okay, so if the counsel is just being disobedient and stubborn, that's good enough. Why couldn't they just say that?
Cleo says some of us need to watch Sesame Street reruns.
Romper Room, all that shit.
Right.
Yeah, I'm a dumb cop. I'm a dumb cop, man.
Let's see. Rescue just sent me the definition. Hold on.
Courts must also.
Yep, stubborn.
Yeah.
Or willfully disobedient. Yeah.
Courts must also balance the needs of the public and victims. The general public and victims of crime also have an interest in the even-handed administration of justice. Absolutely. That's a huge statement to me. Trial courts have the discretion to balance these interests with the defendant's desire to be represented by his preferred counsel. All right, but just because he desires it doesn't mean that that's going to happen, especially when he's indigent. Though varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy. This should only be used when a court deems it reasonably necessary to ensure the integrity of the fact-finding process, the fairness or appearance of fairness of a trial. I'm glad they put that or appearance in there. the orderly or efficient administration of justice, or public trust or confidence in the criminal justice system. We don't seem to have a lot of confidence in the criminal justice system revolving around this case. Lack of record prevents review of counsel's disqualification. Defense counsel's withdrawal, Jesus Christ, truncated the proceedings. There we go. And the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. In chambers, prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified that it intended to address at the hearing. The prosecutor was prepared to present evidence from the leak investigation, but the hearing did not occur because the defense counsel withdrew rather than challenge the factual allegations at the time. And that's what I'm saying. She gave them a break. She shouldn't have done that in hindsight. At the October 31st hearing, where Baldwin and Rossi attempted to appear for Allen and had their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. Good point. Excellent point. Yeah, I need hooked on phonics, Cleo. All right, Cleo, don't give me that shit. You wouldn't have got hung up on that one? Don't give me that shit, girlfriend. Respondents raised concerns that could warrant disqualification depending on the circumstances. The court's concerns raised questions regarding counsel's compliance with professional ethics and ability to provide Allen effective representation. After the state sought a gag order, counsel had assured the court they did not intend to try the case in the media. Let me read that part again. Counsel had assured the court they did not intend to trial the case in the media. That's bullshit. But then issued a detailed press release challenging specific evidence that the court believed violated professional conduct rules. The restriction on public commenting on specific evidence and related limits on pretrial publicity exist to protect the defendant's right to a fair trial and the availability of an impartial jury. Dude, I don't know how they're going to get an impartial jury at this point.
That's my whole point, dude. That's why I don't think it'll ever go to trial.
Dude, it's going to be one of these. Knock, knock. Who's there? Richard Allen. Richard Allen who? All right, you're on the jury.
I got to put you on mute for a minute.
Go ahead. Rescue. You laughing at Cleo making fun of me? Is that what we're doing now? Okay. All right. I'm taking notes. The court expressed concerns about the counsel's candor. Baldwin informed no one that the defense outline had been sent to the third party for months until the state discovered it. The court noted prior filings appeared to make factual allegations without foundation, which were then disproved. Now, as far as that goes, right, let's talk about the tip that either Doolin never saw, didn't get filed properly, nobody looked into it, the FBI allegedly misfiled it, they say they did not. Okay, so that, it pisses me off, right? That shit pisses me way the fuck off. But also, on the same lines, this shit here, Baldwin never said anything. He knew he fucked up, but he never said anything. This record does not contain the transcripts necessary to evaluate these concerns, but the concerns raise potential ethical issues and concerns for competent representation. Now, look at it. See Outback Steakhouse of Florida versus Milwaukee, noting attorneys may not make false or misleading statements to the tribunal, and that such conduct may be prejudicial. Justice counsel conduct could implicate a conflict of interest or endanger Allen's ability to secure an impartial jury. Defense counsel permitted 2 separate leaks of protected material, including graphic crime scene images. Public dissemination of graphic crime scene images could inflame prejudice against Allen. Because of the extraordinary public attention to this trial, the court imposed a strict protective order on all discovery. The record contains incomplete and inconsistent information regarding the extent of the leaks and the counsel's role in them. An affidavit from a friend and former employee of Baldwin claims responsibility for taking of the photos without counsel's knowledge. But a letter from the counsel to the court indicates that counsel regularly consulted the same friend about the case and defense strategy. It's unclear whether the friend was given access to protected discovery or privileged information during these consultations. The record also does not reveal what law enforcement learned about the extent of the leak or counsel's role in it, and the investigation appears to be ongoing. Investigations into the potential liability for counsel's conduct during the representation can give rise to a conflict of interest requiring removal. The court also expressed concern that the counsel obtained a financial interest in the proceedings by filing a notice of tort claim related to Allen's pretrial confinement. Whether circumstances exist that would divide counsel's loyalty between Allen and their own interest is unclear. All right, so they're not saying that tort claim, would divide their loyalty, but it's just not a good idea.
Right.
The record is also inadequate for a full. I'm sorry, Frank. I didn't know you were back, brother.
Oh yeah, it was our friend up in Carmel.
I don't know who that is.
Yeah, you do.
The record is also inadequate.
She should be here in chat.
Okay, now I know who it is. But full
Yeah.
consideration of Allen's preference. So you left my live to take a phone call from her. What's up,
She
Noe?
called, man.
Okay.
What's
You
up,
don't have
Noe?
caller ID.
Yeah, and it said her name right on the front of it.
The record, all right. As long as I know where I stand on the pecking order, that's all. As long as I know where I'm at in the food chain. The record contains expressions of Allen's desire to retain Baldwin and Rozzi after being informed of the leak. But the record does not show what Allen knew or understood regarding the leak, the court's order, the court's other concerns about the counsel's competence, how those matters impacted his ability to obtain a fair trial, or the alternatives available to him. So that's a great point right there. How much did Richard Allen know about the leaks?
That's telling you. He knew about it prior to all this going on.
You think Richard Allen knew about all this?
Yeah.
Hmm.
He knew about it because why would you write to court saying he wants to keep them as attorneys? So he had to have known something.
I don't believe that he wrote to the courts. I think they wrote it and had him sign it.
Well,
I don't think he knows what the hell's going on, to be honest with you, what their plan is and all that.
I mean, it does sound legit that they could have just typed up something and had him. Well, they didn't type it; it was obviously written.
Mm-hmm. Well, we seen his first letter to the judge when he's saying, "Hey, I'm indigent," And like I said before, my thing would have been 3 words: "What the fuck?" That's what I would have wrote to the judge. You taking my attorneys? But they filled his head up with lies. Taken as true, the existing assertions of Allen's preference are insufficient to determine that he is making an informed decision. The presumption of defense to the defendant's choice is strengthened by confidence that is informed and individual choice by the defendant. Inquiry and advisements from the court are needed to ensure Allen understands the risks and gains of his choice. Now, that's a little iffy, isn't it? So they're saying that the court should pull him aside and say, "Hey, listen, man, these guys are fucking up. They're doing this, they're doing that. They're hurting your case." That's a little twisted, isn't it?
Yeah.
I've never seen that one before. That's a new one. I've never even seen that suggested, that it's the court's job to do that, to make sure he understands that. The court's discretionary decision could be reviewed on appeal with a complete record, but the limited review in this action is inappropriate. Courts have discretion to remove counsel for gross incompetence or inappropriate conduct that cannot be adequately addressed through contempt. So a lot of people were saying that she could have just fined them,
right,
and
put an injunction,
charged them with contempt. Yeah,
right.
Yeah, it's crazy. Yeah, well, that
But then again, you got to go back. This is the third time this has happened. She's done warned him twice before.
yeah,
And
that's
you
true.
know how it is. The habitual offender rule is 3 strikes and you're out.
Yeah,
You know.
but Humanimal, that asshole Baston that wrote that letter saying he's been
Yeah.
mistreated, he does that everywhere he goes. They have to keep moving him because inmates want to kill him. That son of a bitch took an 8-year-old girl away from a pool party, took her out in the woods for a ride on his ATV, and committed sexual acts with her. That's why he's in that situation he's in now. So fuck him.
Right.
This requires more general concerns that counsel is not handling the case as well as they should. Now, who decides that, though? That I do agree with some people on. You know, who the hell is she to say? Do you know what I mean? I would still hire either one of these guys, Frank. They got balls. They got balls.
Yeah, but it's clearly evident that they were trying to taint some type of jury pool that's out there, and she's trying to prevent that from happening. It's blatantly obvious why this is all going on.
But the extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. So this writ shouldn't even be where it's at.
Right.
This is such a case. So it being moot is basically she's correct. She may be getting a little snarky, but it appears that she's correct. This is what the Attorney General is agreeing with. So Allen has not asked this court to mandate further proceedings, but an outcome. So I agree with that. I agree with that 100%. He's not saying, hey, this needs to be looked into. He's saying, no, you need to give me back these attorneys. You need to get rid of that judge. You need to take me to trial within 7 days. That's not how it works, kids. Allen seeks a combination of relief, reinstatement of counsel, removal of the judge, and trial within 70 days of the writ. That would not permit respondent or any successor judge to undertake further proceedings prior to trial. This is inappropriate to decide whether the trial court abused this discretion. Writs may issue to compel lower courts to act on matters within their discretion, but they are not appropriate to dictate how that discretion is exercised. The balance between the defendant's ability to choose representation and his right to effective representation warrants comprehensive appellate review, not the expedited and truncated. Here we go again. Truncated. Truncated. Somebody tell me what that one means.
They basically trumped the appellate court, went straight to the Supreme Court.
Yeah, well, tell me what that word means, asshole.
That's what I'm basically telling you. They
okay.
want to.
Okay. The request of the court order trial to commence within 70 days is improper, as Allen has not requested this relief in the trial court. Now, I am under the impression, and I have been under the impression, that he waived his right to a speedy trial.
Right.
So, as his second request for relief, Allen asked the court to order his trial to commence within 70 days of the issuance of the writ. Allen has not moved for an early trial under Indiana Criminal Rule 4. Allen points to the fact that he signed a motion on August 2023 requesting an early trial that has been purposefully not been filed with the court. So what are they saying? That he filled it out, but he has not filed it?
That his attorneys never filed, or somebody didn't file it.
Right.
Well, then that would mean that his attorneys would have had to have filed it.
Yeah. Yeah. Well, we'll see what happens with his new attorneys. A trial court cannot act on a motion that has never been presented to it. Until the trial court has shown by some ruling or refusal to act that it's exceeding or failing to exercise its jurisdiction, there is no basis for action. And that's what I was saying before. She told him that in that hearing. You know, You want relief from that? File something. You want to have a hearing? I'll have a hearing. You know, Allen can file a motion for early trial at any time, and the trial court must set the trial date within 70 days. Because Allen has not yet requested an early trial, it is improper for him to ask this court to order that relief in the first instance. Okay, so if he was innocent, why didn't he do that right off the bat?
Right.
Why didn't his
That's
attorneys
all.
tell him first thing, let's go to trial in 70 days? No, they're the ones that kept postponing it.
Yep.
They're,
They filed the first continuance in February of 2023.
yeah, they wanted to have a bail hearing. Well, then they they got some of that discovery and said, oh,
Discovery.
shoot. Yeah,
Right.
let's switch this to he's being mistreated because Max, 20-year-old Max, told us that he's being mistreated and he has a dirty T-shirt on.
That was a joke.
Yeah. The request that this court replace Judge Gull is improper, as that request has not been properly presented to the trial court. As a third request of relief sought, Allen asked the court to remove Judge Gull and appoint a new special judge. This request is improper as Allen has not asked for this relief from the trial court. It is true that after he withdrew, Rozzi filed a motion to disqualify. However, at the time that Rozzi filed the motion, he was no longer Allen's attorney, so Judge Gull did not take any action on the motion. Allen cites no authority that the trial court must entertain a motion by an attorney who is not the party's current attorney. Allen does not meet the condition precedent of Rule 2A because Allen did not first request this relief in writing from the trial court. It is improper to request this relief now. Further, Allen fails to show that a remedy by appeal is not adequate. Current counsel could have filed Rosie, ring around the Rosie's motion to sought an interlocutory appeal. Dude, what the fuck? Can't these guys just use regular Boston asshole words? Is it that hard to use just regular?
Oh, Lord.
Yeah. Fucking assholes. They're doing this just to fuck with me is what they're doing. Brad, I think he's going to plead out. That's my opinion.
Yeah, that's mine too. And
Interlocutory. Dude, I'm going to go by that word 100 million times now and never fuck it up again. The appellate process is adequate to correct any abuse of the respondent's court's discretion in denying relative's motion for a change of judge. A writ is inappropriate because Allen has a remedy through the appellate process. He can file his motion for change of judge, and if denied, he can appeal that decision. Now, these people that are filing all this paperwork, Winicky and Freelo and all those people, they are appellate attorneys. All of them.
So why are they filing it with the Supreme Court then? That's the question.
Yeah, well, they're thinking that it's okay. That that's what appellate attorneys do. They don't deal with lower courts,
right?
At all. What up, Sleuth?
What up, Sleuth?
Finally, Allen only points to the judge's rulings in this case to argue the judge is biased. This is not sufficient. The mere assertion that a certain adverse rulings by a judge constitute bias and prejudice does not establish the requisite showing of personal bias or prejudice. Even if properly before the court, this record does not support a change of judge. Conclusion: because the precise relief requested by Allen is not appropriate for resolution in this original action, this court should deny the writ. Now, what do you think about that thing in whole?
The only question I see that people were talking about was if she had the authority to get rid of Rosie and Baldwin. Well, it clearly states in the United States Constitution that she had the authority to.
Mm-hmm.
That's the only thing I would have to say to people is he pulled the law on you guys. So trying to say that he didn't have his Sixth Amendment right was violated. No, it wasn't, guys. Not at all.
Right.
No other proceedings or anything was done from the time they verbally resigned from the case in her chambers on the 19th. No other action was done on the case until new attorneys were assigned to the case. And that's the way it's supposed to be. That's what the law says. You cannot continue with a case until he has legal representation.
Right.
Which she had two new attorneys signed, a week later?
Mm-hmm. Mm-hmm.
So
Well, I don't like to run too long. We've still got this whole other one to go. We've been an hour and a half. I don't want to do a 3 hour damn live.
Well, I got a live in an hour.
Yeah, so if you want, you can do the goals.
Yeah, we could do the goal on mine.
Yeah.
So,
I don't feel
but
like
yeah, man.
running into any more big words.
Well, we'll probably do it in hers too. So,
Yeah.
but like I said, I think it was spot on what Rakita was saying.
What's that?
They completely avoided the appellate court, went straight to, and he's right. There's procedures that they have to follow, and they didn't follow procedures themselves.
Yeah, absolutely.
I mean, I could have swore that the Supreme Court had issued an order a couple weeks ago telling them that they filed stuff wrong.
Right.
Stuff was filed wrong.
They should know that, though. With 50 years of experience between the two of them, they should know that.
Well, it's not only them. I'm talking about the appellate attorneys also.
Yeah.
They were doing the same thing, you know?
Yeah, exactly. Exactly. But, that's their shtick. That's what they do. I mean, they can play stupid all they want.
But I'm going to say it again, and I'll keep saying it. Richard Allen, your goose is cooked, bro.
Yeah, he's fucked.
Your goose is cooked.
Yeah, I know his goose is.
I don't know how Judge Gull's going to take that.
Yeah, well, she doesn't have a choice. She doesn't have a choice. They can hire whoever they want to help.
Right. But otherwise, bro, in an hour, we'll read Judge Gull's on mine.
All right, man. Thanks for coming on. I appreciate it.
Hey, no problem, bro. Nice seeing everybody in the chat, man. I know it's been a few weeks, but y'all know how I work. If it's not pertinent enough to go live, I'm not doing a live because everybody and their mother's doing the same thing. So,
yep.
But I'll see everybody in an hour.
I see you, bud. All right, guys. I thank you so much for your support, for your likes and shares and super chats. You guys are awesome. I appreciate that. If you guys have any questions for me, you can put it on my community page or email him on the bottom of my the ticker going on the bottom there. You can email me anything. But I'll be back on in a couple days. I've got some more stuff on the Huff case. I've actually got some victims' families that I'm going to bring on and a retired detective. So we're going to get going on that asshole, trying to get him. He's walking around the streets in Florida, and we need to get his ass in on death row. So I appreciate y'all coming. Guys, please, don't take any wooden nickels. My name is Ruckus. Thanks for hanging out. Please like, subscribe, and share. I'm 10-7.